Hello everyone, this is host William. Welcome to our EB2 NIW, National Interest Waiver, Green Card Application Learning class. We will let you know detailed NIW Green Card application process, and step-by-step knowledge of how to get your US Green Card quickly. Before start the video, I hope the audience will give a thumbs up first, provide comments, and subscribe to our YouTube channel, to let the knowledge of US Green Card application spread to more immigrants, and let YouTube's algorithm recommends our videos to more viewers. For further and detailed information of US Green Card application, please visit our very helpful website greencardapply.com. Thank you. What are the USCIS suggested criteria and factors for National Interest Waiver, NIW, applications? For Form I-140 petitions in EB2 category, an employer should normally offer the alien employee a job position, except when the alien is seeking an exemption from the job offer requirement. In the job offer exception case, the alien may file the petition in the EB2 National Interest Waiver category. To be exempt from the job offer requirement, the USCIS will determine if an exemption would be in the U.S. national interest. A labor certification is not required if the job offer requirement is waived. If the presence of a worker can be shown to be of benefit to the U.S. in the future, it may be possible to apply in NIW without having a job offer or labor certification. In order to demonstrably benefit the United States, the alien applicant will have to show that his or her there will have a favorable impact on the country's economic, employment, educational, housing, environmental, or cultural situation, or on some other important aspects. The impact must be national in scope, such that a public health researcher at a federal agency or a university might pass, while the same person coming to provide services at a neighborhood clinic would probably not. The alien applicant will also need to prove that the field of work has substantial merit, in other words, that it is worthy in and of itself. In addition, the applicant will need to demonstrate that the work will prospectively benefit the U.S. national interest to a substantially greater degree. Unfortunately, USCIS often reinterprets this requirement to mean showing that being forced to go through the labor certification process would actually have an impact on the U.S. national interest. A person may qualify for the EB2 National Interest Waiver category, if he or she falls within the second preference employment-based category, namely a person in the professions who either holds an advanced degree, or is considered possessing exceptional ability in the sciences, business, or arts. For EB2 National Interest Waiver application, the U.S. immigration law only requires that the alien's activity has a prospective national benefit. The USCIS has clarified what conditions the alien applicant may be granted the National Interest Waiver, in which an alien applicant must meet one or more of the following. 1. Improving the U.S. economy. 2. Improving wages and working conditions of U.S. workers. 3. Improving education and training programs for U.S. children and underqualified workers. 4. Improving health care. 5. Providing more affordable housing for young and/or older, poorer U.S. residents. 6. Improving the environment of the U.S. and making more productive use of natural resources. 7. A request from an interested U.S. government agency or improving international cultural understanding. The alien applicants do not need to meet all above requirements, but only one or more of them in order to qualify EB2 NIW application. Also, there are a number of rules or case law criteria that the USCIS regularly employs for EB2 National Interest Waiver petition, that are considered in the adjudication of the National Interest Waiver application. Typically, alien applicants should establish themselves as having some unique and exceptional skill, experience, or knowledge that sets them apart from their professional peers. Documents stating that he or she only possesses a certain level of competence will not be sufficient to receive a national interest waiver approval. Rather, a proficiency that is greater than mere competence is expected for those seeking a national interest waiver application approval. Under the new USCIS framework in matter of Dhanasar, after eligibility for EB2 classification has been established, USCIS may grant a national interest waiver if the petitioner demonstrates by a preponderance of the evidence. 1. The foreign national's proposed endeavor has both substantial merit and national importance. 2. The foreign national is well positioned to advance the proposed endeavor, and 3. On balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. While neither the statute nor the pertinent regulations define the term national interest, USCIS has set forth a framework for adjudicating national interest waiver petitions. To be eligible for a national interest waiver, NIW, applicants must demonstrate that their work is in the national interest of the United States, their proposed endeavor is of substantial merit and national importance, they are well positioned to execute their proposed endeavor, it would be in the national interest to waive the job offer and perm certification requirements. The USCIS may also consider the applicant's education and skills, their past achievements and record of success, their model or plan for activities related to the proposed endeavor, any patents, trademarks, or copyrights they developed, interest or support garnered from potential customers or investors. Other evidence of NIW eligibility may include 1. An official academic record. 2. Letters documenting of experience. 3. A license or certification to practice your profession. 4. Evidence of remuneration for services. 5. Membership in a professional association. 6. Recognition for achievements and contributions to your industry. How to meet the EB2 NIW requirements of matter of Dhanasar, which is a clearer framework for adjudicating EB2 national interest waiver applications. For years, the USCIS had declined to issue a comprehensive and controlling definition of national interest, and instead had advised the USCIS service centers to treat petitions involving national interest waiver requests on a case-by-case basis. In 1998, the USCIS designated its first precedent decision discussing the standards governing the EB2 national interest waiver petitions. Matter of New York Department of Transportation, NISDOT, establishes stricter standards for obtaining national interest waivers than those applicable in the past. The NISDOT case sets up a three-pronged test to establish eligibility for the national interest waiver petition. 1. The foreign national must seek employment in an area of substantial intrinsic merit. 2. The petitioner must demonstrate that the proposed benefit will be national in scope, and 3. The petitioner must demonstrate persuasively that the national interest would be adversely affected if a labor certification were required for the beneficiary, i.e., that it would be contrary to the national interest to potentially deprive the employer of the foreign national's services by requiring that the position be available to U.S. workers, and b. that the foreign national will serve the national interest to a substantially greater degree than would an available U.S. worker having the same minimum qualifications. The precedent NIS. Decision continues the trend of tightening the standards for national interest waivers. Under the standards, such waivers proven more difficult to obtain. However, in recent years, USCIS service centers began to apply a more exacting standard to EB2 National Interest Waiver petitions, requiring petitioners to establish that the alien possesses unique knowledge, abilities, or experience that set him or her apart from others in the field. In matter of Dhanasar, that USCIS Administrative Appeals Office, AAO, released on December 27, 2016, AAO created a precedential new test for a EB2 National Interest Waiver petition in sustaining the appeal, and approved the National Interest Waiver petition. For an EB2 National Interest Waiver petition, USCIS may grant a National Interest Waiver of the labor certification, which allows for self-petitioning by the foreign national, if the petitioner demonstrates that the alien is a member of the profession holding an advanced degree or equivalent, or because of exceptional ability in the arts, sciences, or business, and will substantially contribute to the U.S. economy, culture, educational interests, or welfare. The foreign national's services must be in the sciences, arts, professions, or business. In matter of Dhanasar, the AAO held that the NIS. Analysis caused much confusion, and had a tendency to lead to unnecessary subject evaluation. AAO held that it was vacating NIS. Criteria, and adopting a new and clearer framework for adjudicating EB2 National Interest Waiver petitions. Under the new framework in matter of Dhanasar, after eligibility for EB2 classification has been established, USCIS may grant a national interest waiver if the petitioner demonstrates by a preponderance of the evidence. 1. The foreign national's proposed endeavor has both substantial merit and national importance. 2. The foreign national is well positioned to advance the proposed endeavor, and 3. On balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. If these three elements are satisfied, USCIS may approve the national interest waiver as a matter of discretion. To meet the NIW matter of Dhanasar standard, an applicant must demonstrate that their proposed endeavor has substantial merit and national importance, that they are well positioned to advance that endeavor, and that waiving the job offer requirement would be beneficial to the United States, essentially proving that their work will significantly benefit the country even without a U.S. job offer. This is achieved by presenting strong evidence in each of the three prongs established by the case law. Prong 1, substantial merit and national importance. Show that your proposed work has significant value and is relevant to a broad national issue in fields like science, technology, healthcare, business, or culture. Provide evidence of the potential impact your work could have on the U.S. Demonstrate the inherent merit of your proposed endeavor, even if immediate economic benefits are not readily apparent. Prong 2, well positioned to advance the endeavor. Highlight your qualifications, experience, and achievements in your field that directly relate to your proposed endeavor. Present a detailed plan outlining how you will execute your work and achieve the desired outcomes. Showcase your expertise and ability to lead the project to success. Prong 3, benefit to the United States. Explain why waiving the job offer requirement would be in the national interest. Demonstrate that your work cannot be readily accomplished by a U.S. worker or that your contributions would significantly outweigh the need for a labor certification. Consider potential economic, social, or scientific benefits that would accrue to the U.S. due to your work. Question and answer. Question: I am in the process to file EB2 NIW application. What supporting evidence will best show that I will significantly contribute to the national interest? Do I have to have reference letters or many publications and citations for NIW application? The reference letters or recommendation letters are very important for EB2 National Interest Waiver application. The independent reference letters from those who have never worked or collaborated with you will carry much more weight with the USCIS than reference letters from dependent recommenders. The reference letters should discuss the alien applicant's research contributions and their significance, and should comment directly on the benefit of alien applicant to U.S. The reference letters are also a great opportunity to demonstrate the implementation of the alien applicant's work. A reference letter from someone who has utilized the alien applicant's work, and can explain how they have done so, is a great way to strengthen an EB2 NIW petition. Unlike EB1 Extraordinary Ability Petition, or EB1A, the standards of EB2 National Interest Waiver Petition are more flexible. There is no requirement of minimum number of publications and citations. While frequent citations can certainly bolster a researcher's claim to have influenced the field, the lack of frequent citation is not a bar to eligibility where other objective evidence of the petitioner's influence exists. Also, merely being cited substantially does not by itself establish the applicant's eligibility for EB2 National Interest Waiver. Original and significant contribution to the field is an essential consideration for the USCIS to decide on an EB2 National Interest Waiver application, and establishing the petitioner's contribution relies heavily on strong reference letters. Therefore, the reference letters and the content of these letters are critical to establish your original and substantial contribution in the field. The EB2 NIW applicant must show how they will serve U.S. national interests to a substantially greater degree than could a U.S. worker with the same qualifications. Some of the best supporting evidence for a national interest waiver application includes: 1. Letters of recommendation. These are a crucial part of an NIW petition, and should come from experts in the applicant's field. 2. Publications and citation records. A complete publication record demonstrates the applicant's past scientific achievements, government funding or grants. Funding from reputable institutions or government agencies can show the national importance of the applicant's work. 3. Awards. Awards that are nationally or internationally recognized and specifically given to the applicant can strengthen the petition. 4. Evidence of influence. This can include citations, letters of recommendation, patents, contracts, and article downloads. 5. Evidence of contributions. This can include a track record of success on a specific project, and a description of the applicant's role in the project. 6. Agreements with potential customers or users. These can show progress towards achieving the proposed endeavor. 7. Letters of intent from clients or partners. These can show that the project has already generated interest. 8. Evidence of licensure. Licenses, registrations, and certifications can demonstrate special qualifications and expertise. Thank you for watching the video. We offer high-quality complete do-it-yourself packages for U.S. green card application and working visa application, and we provide many samples of reference letters, and samples of petition cover letters for U.S. immigration and green card application, and we also let you know the U.S. green card application process and how to get your green card quickly. If you want to apply for a U.S. green card, our website greencardapply.com and complete do-it-yourself packages can help you get green card quickly, even without an U.S. employer sponsorship, and bypass the labor certification process. I hope the audience will give us a thumbs up, provide comments, and subscribe to our YouTube channel, to let the knowledge of U.S. green card application spread to more immigrants, and let YouTube's algorithm recommends our videos to more viewers. For further and detailed information of U.S. green card application, please visit our website greencardapply.com. Thank you.